Picture this. You wake up tomorrow, check your mail, and find a single envelope that shatters everything you've built over the last 10, 15, maybe 20 years. It's not a bill. It's not junk mail. It's a notice telling you that your legal right to stay in the United States is being questioned, and in some cases, revoked. Your job? Gone. Your home? At risk. Your family? Facing separation. All because of something you didn't even realize was a problem. Now here's the part that should terrify you. This isn't happening to people who are knowingly breaking the law. It's happening to immigrants who thought they were doing everything right. People who paid their taxes. People who showed up to work every day. People who raised their children here, bought homes, built businesses, contributed to their communities. And yet, one mistake, sometimes a mistake they made years ago and forgot about, comes back and destroys everything.
That's the brutal reality of immigration law in America today. You can be a model resident. You can follow every rule you know. But if you don't understand the hidden traps buried in the system, you're vulnerable. And once those traps are triggered, the consequences come fast. Too fast to react, too fast to fix. So if you hold a green card, a work visa, or any type of legal immigration status in the United States, what you're about to read isn't just information, it's protection. Because today we're going to walk through 5 critical mistakes that can destroy your immigration status, and more importantly, how to make sure you never fall into these traps. Let's begin with the first and most misunderstood danger, serious criminal convictions. When most people hear serious criminal conviction, they think of major crimes, armed robbery, assault with a weapon, major fraud, things that obviously carry heavy legal consequences. But immigration law doesn't work the way most people think. There's a category of offenses called aggravated felonies. And here's where it gets dangerous and confusing. Under immigration law, an aggravated felony is not necessarily the same thing as a felony under your state's criminal code. Let me say that again because it's critical. You could be charged with a misdemeanor in state court. You could pay a fine. You could serve 0 jail time. You could walk out of court thinking the whole thing is behind you. But under federal immigration law, that same offense might still be classified as an aggravated felony. And once that label is attached, everything changes. Because aggravated felonies are among the fastest routes to deportation under immigration law. It doesn't matter how long you've lived in the United States. It doesn't matter if your children are US citizens. It doesn't matter if you own property, run a business, or have deep ties to your community. Once you're convicted of what immigration law considers an aggravated felony, your legal status is in immediate jeopardy. Let me paint a real-world picture. Imagine you've been in the US for 15 years. You have a green card. You work full-time, you own a home, your kids go to school here, your entire life is here. One night, something goes wrong. Maybe it's an argument that escalates. Maybe it's a misunderstanding over property. Maybe it's something you never imagined would become a legal issue. You're arrested, you're charged with what the prosecutor calls a minor offense. Your lawyer tells you, just plead guilty, pay the fine, do some community service. It's not a big deal. It sounds reasonable. You want to move on. You accept the deal. Case closed, or so you think. Months pass, maybe even years. Then one day, you apply to renew your green card, or you travel abroad and try to return, or immigration authorities conduct a routine review of your file. Suddenly, you get a notice. You're being called before an immigration judge. Why? Because that misdemeanor conviction you accepted years ago has now been classified as an aggravated felony under immigration law, and now you're facing mandatory detention, possible deportation, limited legal options. Your years in the country? Doesn't matter. Your family ties? Doesn't matter. Your contributions to your community? Doesn't matter. Because once that classification is made, immigration judges have very little discretion. This is why the advice I'm about to give you could be the most important thing you ever hear. If you are ever arrested for anything, you need more than a criminal lawyer. You need an immigration attorney involved from day one. Because what looks like a smart plea deal in criminal court can be a disaster in immigration law. And once you accept it, the damage is often irreversible. Now let's move to the second mistake, drug-related charges. This is one of the harshest and least forgiving areas of immigration law. Many people assume that small drug offenses won't matter much. Maybe it's just a little possession. Maybe it's something recreational. Maybe it's legal in your state. But here's the problem. Immigration law operates at the federal level, and at the federal level, drug offenses are treated with extreme severity. We're talking about possession of cocaine, even a trace amount, possession of heroin, even residue, possession of prescription drugs that weren't prescribed to you, possession of methamphetamines, ecstasy, or virtually any controlled substance. The amount doesn't matter. You could be caught with a single pill, a tiny amount in a baggie, a trace left in your pocket. Under immigration law, that's enough to trigger deportation proceedings. Now, there is one very narrow exception involving marijuana. If you're charged with possession of less than 30 grams, and it's your first offense, you might avoid immigration consequences. But notice how specific that is. Less than 30 grams, first offense only. And even then, it's not guaranteed. Different courts interpret the exception differently. So even in the best case scenario, you're taking a risk. Here's something even more alarming. You don't always need a conviction to face immigration consequences. Let's say you're arrested on drug charges. You hire a lawyer. You work out a deal. Maybe the prosecutor offers you a diversion program. You complete it successfully. The charges are dismissed. Your criminal record shows no conviction. You think you're in the clear. But immigration authorities don't always see it that way. If at any point during the legal process you admitted to possessing the drugs, that admission alone can be used against you, even without a conviction. That's how strict the rules are. That's how unforgiving this area of law can be. Think about what that means. You could be a permanent resident who's lived in the US for 20 years. You could have US citizen children. You could own a successful business. But one mistake involving drugs, one moment of poor judgment, can unravel all of it. The immigration system doesn't weigh your contributions. It doesn't consider your family. When it comes to drugs, the law is rigid, cold, and brutally efficient. Now let's talk about the third major threat: domestic disputes and family violence. This is another area where people often underestimate the consequences, because these situations are emotional. They happen in the heat of the moment. Arguments escalate, police get called, charges are filed. Sometimes the people involved don't even want to press charges, but the legal system moves forward anyway, and what starts as a personal matter quickly becomes a legal nightmare. Under immigration law, domestic violence is taken extremely seriously, and the definition is broader than most people realize. It doesn't just include physical harm, it includes threats, unwanted touching, blocking someone's path during an argument, violating a restraining order, even unintentionally, and it applies to a wide range of relationships: spouses, ex-spouses, partners you live with, children, including stepchildren, anyone who shares your household. Here's what makes this particularly dangerous. In many cases, domestic violence charges are prosecuted as misdemeanors. You might not face jail time. You might be offered counseling or anger management classes. The local prosecutor might treat it as a minor offense, but under federal immigration law, it's not minor at all. A single misdemeanor domestic violence conviction can make you deportable. Let me give you a real-world scenario. You're in a relationship that's falling apart. Emotions are running high. During an argument, things get physical. Maybe there's pushing, maybe there's yelling. The police are called, you're arrested, you're charged with domestic violence. A prosecutor offers you a deal. Plead guilty to a misdemeanor. Take some classes. Avoid jail time. It sounds reasonable. You want to move on. You accept the deal. But here's what just happened. You've now been convicted of a deportable offense. When immigration authorities review your file, whether during a green card renewal, a citizenship application, or a random audit, they'll see that conviction. And unlike criminal court, where judges can consider context and mitigating factors, immigration judges have very limited flexibility. Your legal status is now at risk. Your years in the country may not save you. Your family ties may not save you, all because of one misdemeanor conviction. This is why you should never accept a plea deal in a domestic violence case without consulting an immigration attorney. There may be alternative resolutions. There may be ways to structure the plea that protect your status, but you'll never know unless you ask before it's too late. Now let's move to the fourth mistake: immigration fraud. This one is different because it doesn't always involve something recent. It can come from something you did years ago, maybe even decades ago. Immigration fraud includes lying on immigration forms, even about things that seem small, using fake or altered documents, entering into a marriage solely for immigration benefits, misrepresenting facts during interviews with immigration officials. At the time, these actions might seem harmless, or necessary, or like something everyone does. But immigration law doesn't forget. There is no statute of limitations on fraud. That means something from 10, 15, even 20 years ago can come. Imagine this. You got your green card 20 years ago. You've lived a stable, lawful life ever since. No criminal issues, no problems. Everything seems fine. Then one day your case is reviewed, maybe during a citizenship application, maybe during a routine check. Something doesn't match. An investigation begins, and suddenly your past is back. If fraud is discovered, your green card can be revoked. Deportation proceedings can begin, even after 2 decades of lawful residence. That's how serious this is. And it doesn't just apply to your original application, it applies to everything you've ever submitted. Visa applications, work permits, travel documents, petitions for family members. Every detail matters. Even small misrepresentations can have major consequences. That's why honesty isn't just important, it's essential. Now let's talk about the 5th mistake. And this one might surprise you, because it seems so small, almost insignificant. Failing to update your address. Yes, something as simple as not reporting a change of address can create problems. Under U.S. law, green card holders and certain other immigrants are required to report any change of address within 10 days. Not 10 business days, 10 calendar days. Most people don't know this, or they forget, or they assume it doesn't matter, but it does. On its own, this mistake might not lead to deportation, but it can become part of a bigger problem. If you're ever in legal proceedings, it can be used to show non-compliance. It can affect your credibility. It can make your case harder to defend. And the worst part? It's so easy to avoid. Updating your address takes minutes online, but ignoring it can create complications later. Now step back and look at the bigger picture. What do all these mistakes have in common? They often don't feel serious in the moment. They seem manageable, temporary, like things you can deal with later. But immigration law doesn't work that way. It doesn't give second chances. It doesn't always consider intent. It looks at facts, records, classifications. And once something is on your record, it can follow you for life. And here's something else you need to understand. The immigration system today is faster and stricter than many people expect. Cases move quickly. Decisions are made faster. Opportunities to fix mistakes are limited, which means prevention is everything. So what can you actually do to protect yourself? First, never make legal decisions without understanding the immigration consequences. If you're dealing with any legal issue, especially criminal charges, get advice from an immigration attorney before you act. Second, be completely honest in all immigration matters. No shortcuts, no guesses, no small lies, because those small things can become big problems later. Third, stay organized. Keep records of everything: taxes, employment, housing, family ties. These documents can be critical if you ever need to defend your status. Fourth, stay informed. Immigration policies change. Enforcement priorities shift. What was acceptable before may not be acceptable now. Fifth, if you have any past mistakes on immigration applications, consult with an attorney now, while you're not in removal proceedings. There may be options for coming clean or correcting the record that won't be available later. And finally, treat your status seriously. A green card is not just a document, it's a responsibility. It requires attention, awareness, and care. Because the truth is simple. Your life in the United States is built on your legal status. And protecting that status means understanding the risks, avoiding the mistakes, and making informed decisions every step of the way. Because once something goes wrong, fixing it is often much harder than preventing it. And sometimes it's impossible, so stay aware, stay careful, and most importantly, stay prepared.